when you consider people for this role, above all, whatever particular skills or abilities they need to have, you've got to believe in their integrity. If you don't believe in their integrity, I don't care if they're a CPA and an attorney, whatever qualifications you point to, if you can't believe in their integrity, this person should not be in the position of trustee. Ben and I both emphatically agree with that. This is a fiduciary. You're putting them in a position of great trust, where as a result, there's a great opportunity for mischief, and mischief that may not be easily discovered.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today we're going to talk about trustees. This is a subject that we circle back to periodically. To one of the most important and in some ways challenging aspects of having a trust is making the decision who's going to run it. So those of you who have seen previous shows where we've touched on this topic, I encourage you to go back and revisit those. But now we're wanting to look more closely at some of the considerations that you really need to weigh in making this decision. So often, estate planning that starts out very good, certainly with good intentions, but even with a good document. The terms of the trust are great. You've thought them through. You've thought through, when do you want money paid out, how much, and do you want asset protection features and all those cool things you can have with a trust. But then it'll fall down ultimately or fail to some extent because of a lack of a trustee who can adequately carry out or discharge their responsibilities. So trustees are huge. With us today, Ben Zinkel. Now, Ben, you'll recall, is an attorney with TuckerAllen, and he's been with us in the past. And we want to kind of walk through some of these things to think about. The trustee is not a detail. It's not something that is an afterthought after you've put in all the consideration regarding what you might call the big stuff, the terms of your trust. Some people tend to think, oh, this is just an administrative matter that I just need to touch on. Oh, let me see, kind of as an afterthought. Yeah, let's use my brother, and if my brother can't do it, we'll use, his cousin by marriage or something like that. The bottom line is, it's a huge decision, and it's a shame to come up with terms of a trust that are marvelous, but ultimately fails because you didn't make the right decision regarding trustee. So the trustee is huge. So we're going to take that on today, and let's start with the decision with the most general question of what type of person are you looking for to fill this role? Ben, do you want to charge into that topic first?
I will. So the question of who somebody should pick as their trustee, it comes down to several questions. The first one being the size of their estate and how complicated all of their assets are. If a person has a checking account and a house, and that's about it, then there's really not a lot to administer there. There's going to the bank, getting a check from that checking account. The house, if it's deeded correctly, there's just inheriting that house and either selling it or living in it, setting it up to live. But other than that, there's not a lot to administer there. That's a fairly simple estate that any trustee can, with a little help, can administer with no problem. A lot of people choose family members for this sort of estate. That can also be their beneficiaries. They, like I said, pretty simple. They can meet with, at TuckerAllen, we offer a free consultation after the decedent passes away for their trustees, so we can tell them what to do. And most of the time on simple estates like that, they don't need our help to continue doing that. They just go and administer the estate. So that's the first question, just kind of how big is your estate? How complicated is your estate? And who can you choose to do that? On the flip side, if you have a very complicated estate, say you have a bunch of stocks and a bunch of brokerage accounts and all of these separate things that maybe some have transfer on death designations, hopefully all of them do if this person's funded their trust correctly. But if some of them don't, then you're also looking at probate. And so you want to pick somebody who that isn't in it for the foreseeable future, where they can come in and administer your estate correctly, work with a law firm, go through probate, get all of your assets in one place to continue these trusts. The other thing that you do have to keep in mind also is some people will choose to do continuing trust and lifetime trust in their trust. And we talked about this on previous episodes, but what that means is when a person devises property to their beneficiaries, they can choose to hold that property in a trust itself. And the trustee that they choose for their main trust is oftentimes that same trustee to administer those continuing lifetime trusts.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At TuckerAllen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help you protect your family, your legacy, and your future. From wills and trusts to long-term care and estate planning, count on TuckerAllen, personalized estate planning made simple.
If you're looking at generations of wealth being passed down, you want to choose somebody who is capable of knowing finances, handling these continuing trusts, investing the property in those trusts correctly. So it really is just a matter of the specific client, what their situation is, and whether their inheritance will last for a short time or a long time, the foreseeable future, when they are deciding whether to choose a family member or somebody else for their trustee.
Yeah, you could almost kind of take that idea and ask yourself, are the biggest challenges, as you understand it, going to be more financial, meaning that you can have the complicated portfolio, or is it relatively simple, as Ben was discussing? So if that's the case, then you know that the financial expertise, if it's the latter, can be light, meaning that it doesn't require anybody with a degree in finance or a CPA or somebody who's especially good with money. Now, let's look at, though, what kind of the polar opposite in some ways of ways in which trusts go bad. The other side of the coin is probably a better way to put it than a polar opposite, because they can coexist, actually, financial problems and family problems. So when I talk about the other side of the coin, I'm talking about family problems. Sometimes, the dynamics within a family are so complicated and so discordant that really it takes somebody with tremendous negotiating or interpersonal skills. Think Henry Kissinger. No, maybe not that bad, but the point is, some families, there is a tendency to have conflict. It's just the nature of some families. There's lots of conflict, and there's lots of drama, et cetera. And in some cases, you could have a family that was tranquil until suddenly there was a lot of money on the table. And I can think of a particular example here in St. Louis, and I'm going to not use the name because many people would recognize the name. But this person was a powerful figure in terms of her personality, and she passed away. And her family seemed tranquil, and it seemed that it was harmonious in many ways, at least appeared to be. And then she passes away, and all of a sudden it just spins out of control, and there's litigation in the family, and there's family members no longer talk to each other. The siblings, the children of her, these siblings, the relationships are just, I'm afraid, forever impaired or destroyed. And I guess there was some inevitability to this, but I think that it's sometimes difficult to foresee the level of conflict that might exist. But your challenge when you're doing estate planning is to foresee that, is to try to anticipate it. And this person, I really think that she didn't fully appreciate, the power and influence that she wielded in terms of keeping things in order. And you need to ask yourself, what do you think will happen when you're gone? And is this, even while you're alive and incompetent, which is a comparable scenario, meaning in both cases you're not in a position to exercise authority, so someone else is. And in that scenario, what do you think is happening in terms of the key relationships of those you care about? And if you think that there is conflict or you anticipate that, then you need to give a lot of attention to choosing a trustee who has these strong interpersonal capabilities. Some people can simply mediate well. They could succeed in some field, and that requires a lot of mediation. Contrast that, though, with the first side of the coin I mentioned, which is very knowledge or professionalism heavy in terms of needing somebody who understands investments and understands where to put money and rates of return and risk return analysis and all. So going back to the way Ben sort of summarized it, discussing on the one hand, do you have a relatively simple portfolio, and what alternatively might be the family relationships. And then, as Ben mentioned too, you can't ignore what will be required in terms of longevity of this trust. If you're in your 80s, then this trustee will probably be taking his position of authority perhaps during your lifetime, but in any case, we'll assume in the next 10 to 15 years. So you need to think about the ages of your candidates for trustee. And then one thing that we have to regularly make clear to you, and we have in the past and we will in the future, the single most important criterion is honesty. I mean, you can a lot of things can go wrong, and if the person is honest, they can often be fixed. But if the person is dishonest, whether they have strong interpersonal skills don't really matter. Whether they are a good financial manager doesn't matter, because ultimately things are going to get misused. When you consider people for this role, above all, whatever particular skills or abilities they need to have, you've got to believe in their integrity. If you don't believe in their integrity, I don't care if they're a CPA and an attorney, whatever qualifications you point to, if you can't believe in their integrity, this person should not be in the position of trustee. Ben and I both emphatically agree with that. This is a fiduciary. You're putting them in a position of great trust, where as a result, there's a great opportunity for mischief. And mischief that may not be easily discovered. Now, there are checks and balances. Don't get me wrong. This is not simply somebody who's taking a position on their word or on their honor. There are reports that will be provided. There's information upon request from beneficiaries that have to be provided. These quarterly reports will include information about the assets and their uses, income, expenses, et cetera. So I don't want to overstate the case that you're very vulnerable, but the bottom line is you are vulnerable when you choose somebody who doesn't have integrity to be a trustee. Now let's talk about, though, that scenario where you need somebody that has some versatility, we'll say, maybe more versatility than you can reasonably expect to find in the body of one person. And there is a solution to that, as we've talked about before. When you need somebody on the one hand who does have financial expertise, maybe there's real estate involved, maybe there is farmland. There could be a variety of reasons that we've not given examples of, but are reasons that people regularly need somebody that has some specialized skill or capability to be a trustee. And it's true, a trustee can often delegate to somebody who is not a trustee. They can hire independent contractors as long as they do it in the appropriate way. But ultimately, you want somebody who has enough knowledge about the matter to be able to monitor effectively even somebody they hire as an independent contractor. So there are lots of reasons you want somebody sometimes who is a trustee who has some specialized skill or knowledge because of the assets that are in the trust or will be in the trust. And on the other hand, you may want somebody, though, you may have, and the same need is a lot of complexity, subtlety in terms of dealing with members of the family. So you kind of have it all in one basket, these two very different skill sets. And so how do you resolve that? And the way that you resolve that, Ben, I'll let you run with it.
Okay. Another option you have for your trustees is to appoint what's called co-trustees, and that's exactly how it sounds. You appoint 2 or more people to administer your estate after you pass away or upon your incapacity in certain circumstances. And there are benefits to that. There are also some downsides to that. Some of the benefits are just as you described, the checks and balances of it, and allowing for more skill sets that maybe one person doesn't have. You can have one person be a mediator while 2 or 3 other trustees can have financial know-how or real estate know-how, what have you, to make these decisions for your trust and for your estate after you pass away. It can limit fighting sometimes. If you have an even number of co-trustees, sometimes that doesn't work just because you can tie on things and then you're in the same situation of indecisiveness that you would have if you didn't have co-trustees.
Which means you have to go to court. I mean,
Yes.
Somebody has to break the tie, and it means going to court. And the reason you have the trust is one of the reasons is you want to avoid going to court.
Yes. And that's one of the downsides. Another downside is that if you draft a trust and you allow for co-trustees but don't allow for them to act independently or sign checks or only one of them being able to sign checks, things will come up that while they're administering accounts, banks and credit unions and financial institutions will need every co-trustee's signature on any documents. They'll need all of these things, which kind of is a headache if you are administering a estate and you have multiple co-trustees. Trusts are changeable documents, though, so you can write whatever in your trust. One thing that if anybody is listening, I would highly advise if you're considering co-trustees, allow them to act independently and allow one to sign checks or allow any one of them to sign checks just because it can be a major headache at banks and financial institutes for the same reason that healthcare powers of attorney. You don't want multiple at a time if you're trying to make a split-second medical decision. It's a similar idea there. Having said that, though, co-trustees do help in situations where maybe you want to appoint your children and you know that several of them don't have the required expertise, and you know that they can work together efficiently and effectively.
Yeah, so co-trustees often do make sense. It can cost you a little more. There are comments in Missouri law, the commentary of the Missouri Uniform Trust Code, in which it suggested that just because you have additional trustees does not mean that each is paid as they would otherwise be paid. But neither does it mean that the total cost is unaffected, meaning if whatever it would otherwise have been with one person, if you have 3 people, then each is getting 1/3 of that amount. As you might expect, when you bring on more people, probably the total expenses are going to be higher if they're involved in those decisions. If they participate, as presumably they will. But often it's worth it. Remember, it all is to naught if you create a wonderful plan, but ultimately it fails because it's not administered correctly. And who's in charge of the administration? The trustee. So you have the ability to create terms in your trust, and a good lawyer will help you identify things that you need to address in your trust so that you're not leaving a lot of discretion to the trustee. So the trustee has a roadmap. They have specific instructions as to what they're to do and how they're to do it. But you don't want to reach too far. You do want sufficient flexibility for the trustee to be able to deal with unanticipated developments. So there's a balance between your locking something down in terms of a specific term in the trust and at the same time giving a trustee the flexibility to use his discretion on the spot under circumstances that you couldn't have anticipated and being able to do what you would have wanted them to do. So that's where the trust and the selection part comes in. You want trustees that you share a similar worldview with, especially as to more subtle things, more things that are often interpersonal more so than they are purely monetary. But at the same time, there will be some monetary things to the extent that you have a family business, to the extent that you have particular types of investments, such as a vacation home that you really want preserved. There was a famous case or influential case, I should say, that involved a property where you have income beneficiaries and you have what's called residual beneficiaries. That's simply to say, if you create a trust, you'll have the income to some amount paid out to, we'll say, your children. Then you'll have a provision for whatever's left. The remainder, as it's called, will go to your grandchildren, but that can be under the same terms where it's paid out. But anyway, so during that first generation, you have the settlor who's passed away, so the money is being paid out to the settler's children, and then there's a remainder interest, the thing that's left, the principal, will be going to the grandchildren. Well, it turns out that there was a large part of the assets that were in the trust had actually consisted of this farm where there was a house on it, and the family had gone there for many years, gotten together, and enjoyed each other. So it's an important family time and had been for decades before the death of the settlor. That's you're the settlor. So this was something that the settlor would have thought was important to have, and apparently communicated that in the terms of the trust. So they select a trustee. The trustee takes over, and the trustee decides to hang on to this farmland. Well, it's like 80% of the value of the trust. So you can imagine what the kids are doing. So that the kids are thinking, wait, we could be getting $10,000 a month in income if this were sold and the money were invested in good securities. So they brought in action to court, which you can do. I mean, really, it's a check and balance, actually. It kind of keeps bad trustees in line, where beneficiaries have the right that if they think that the trustee is not following what the settlor wanted, then they have the ability to file an action and go to, it's in probate court, and it doesn't mean that's associated with probate itself. It could be 20 years after you're gone that this happens, but there's just jurisdiction. That's the court that has jurisdiction. So they bring this action, and they want the trustee replaced. And the reason is that they say that the trustee is abusing his discretion because he's failing to maximize the money that's paid to the beneficiaries. And so the trustee defended himself. He hired his own lawyer. Trust pays for his lawyer. And the judge, at the end of the day, agreed with the trustee. The trustee persuaded the court that, look, this is what the settlor would have wanted. This was very, very important to the settlor. Granted, it's not giving the kids as much money as they wanted, but this was what the settlor would have wanted. And the judge agreed, and this was taken up to the Court of Appeals because it seemed like an odd decision that a trustee can can permit 80% of the estate to be tied up this way. And it was, give or take, approximately 80%. And the Court of Appeals agreed. They said, look, the trustee's job is to represent what are the priorities of the person who created the trust, the settlor. And it was upheld. And I thought that was a victory for people such as yourself who create trusts to be able to go out of this world and know that there's going to be somebody thinking about what your priorities were. Now, I don't know that outcome would have happened in all courts. Some courts, there's a danger in some states that the court might have said, look, this trust exists for the benefit of the beneficiaries, and the beneficiaries are all in agreement that they want money and they want the income. And there are some states whose version of the Uniform Trust Code would have been more permissive in this way. So I hope, though, this communicates to you how important a trustee is. I mean, this trustee, I think, really felt that he was doing what was right. It wasn't in his monetary interest to hang on to that. I should throw in that the land wasn't appreciating at some great pace. I mean, it wasn't depreciating, but the point is, some beneficiaries might derive some satisfaction from thinking, oh, well, it's going up 15 to 20% in value, but I don't think there's any evidence that the farm was going up substantially. So selection of trustee is important, but the good news is you can you can have several trustees. You can have trustees that are strong in one skill set and others. One thing that people often don't do is they fail to specify in the terms of the trust what they intend the delegation to be. You can do that. You can put in the trust, and it's even better that you do that. If you have in mind a delegation of authority between say, managing the assets versus dealing with the personal needs of individual beneficiaries. For example, keep in mind that to the extent that it's a fully discretionary trust, which you want it to be, that's a different show, but you want it to be a discretionary trust, then that means that the trustee will have a lot of range of discretion about how much to pay out to the kids at any given time. So that's a very personal decision. It requires some familiarity with what your hierarchy of values, your priorities were. It will be affected by their knowledge of the kids themselves. What's the nature of these kids? Is there drug problems or something else going on? So that just seems like a qualitatively different personality than the person who is going to be a great asset manager. Sometimes they're in the same person, but not always. And there's something to be said simply for having more than one, quite frankly, even if they had very similar skill sets. So it's not just a division of labor consideration. Sometimes there's checks and balances in numbers. And as Ben said, you probably don't want an odd number. I mean, you probably want an odd number. You don't want an even number because, Ben mentioned that if you have a tie, it's going to end up having to be resolved by somebody else. So I'm a little bit of I'm in favor of co-trustees. And often the way that this is done is that somebody will choose what would be considered, you can call them a professional fiduciary, but that doesn't necessarily mean that it's an institutional trustee, but it often does. But you technically could have a professional fiduciary who's an individual, and that's what they do, and they're insured, et cetera. They may be part of a firm, like a law firm, but a firm that focuses on acting in that capacity. But often institutional trustees are banks. There's sometimes called trust companies, bank and trust. And these tend to be insured. They have a lot of professionals involved, so there are advantages to that. And that person that trustee can be in addition to a family member. Some people see that as a great combination. So you have the personal and you have the professional. Do you want to comment? What are your thoughts, Ben?
On whether to use a professional trustee or a personal.
Yeah, or a combination.
Yeah, again, I'll go back to it depends on your estate. More complicated estates, especially ones where, like I mentioned earlier, lifetime trusts, but also charitable remainder trusts, which are a type of trust that people will set up if they want to provide for their family, but also want to give something to charity and have something left over to give to charity after their family passes away or their children pass away down the road. And those trusts require a lot of administering for a long time, 20 years to a lifetime of somebody in some cases. So in those scenarios, it's often beneficial to have an institution or a third-party trustee because you don't know how long people's lifespans will be, but you do know that a bank or a trust company will likely be around for the foreseeable future. So any amount of wealth or trust that are set up, that somebody sets up that will continue for a long time, third-party trustees do have longevity if they are banks or trust companies or law firms or any other corporate fiduciary. That is something going for them there. Impartiality is another great thing that third-party trustees bring in, just as we discussed before. Some people can get very contentious, especially when money is involved. And it's easier for a third-party trustee to say no, and it's a lot easier for them to administer the trust and not breach their fiduciary duties if they are not self-interested in the trust themselves.
Very good points. As a matter of fact, I want to echo thing just to be sure you got it. The longevity that Ben mentioned, it's huge. It's probably the best. I can't say it's the best because I think the best is probably the professionalism that you get, and it's backed by people who are trained in these areas in investment and law, and even better, they're insured. So the professionalism may be the best thing, but But second to that is the longevity, is you have somebody, you almost know you have somebody that's going to be around for many decades. Sure, banks fail, but even when banks fail, you have a successor institution typically, meaning those accounts are usually bought or transferred to a new institution who assumes responsibility for them, particularly if they're profitable, and trusts are profitable. So this is not going to be something where no one's going to want to honor the trust. The funds are protected, meaning the funds are not like funds that the bank turns around and invests. Trust funds are funds that go into an account and they're invested very cautiously. So don't think that whenever you use a bank that the money is going into a bank account like you would otherwise have, which that money, it's true, is lent out to other people. And because of reserve banking, a bank may be only required to keep 10%, literally 10% of their deposits available for depositors to withdraw on short notice. No, these funds are held in very sacred accounts where they have to be invested very conservatively. You can't engage in speculation. There's lots of rules about how to invest money in trust, and so they're very, very highly protected. So I really like the idea of the fact that you have this longevity. The longevity is huge. Now, one thing we should talk about, though, and let me echo again the other point you made, is the fact that sometimes, oddly enough, it probably is helpful to have somebody who isn't in a position to know the intricate details of who did what to who when. I mean, if you're a mediator, true, it's helpful to know that. And again, there are occasions when you do need a trustee that has those capabilities, granted. But Ben's point, which is kind of the other extreme of that, is saying, look, sometimes you just need somebody who is so far above the fray that they're going to simply do what seems fair and right, and whoever's toes that might step on, whoever it might offend, because oddly enough, over time, everybody starts to realize that while they may not have liked a particular decision a few years ago, they may like the decision this year, and soon people start to respect, often, not always, often start to respect the objectivity that somebody brings who is not involved at all, who may not even care about the details of various offenses and indignities or whatnot that have been suffered over time in families. So, lots of good reasons for a professional or an institutional fiduciary. Now, we can't talk about this topic without hitting on cost. Do you want to take the subject of cost and just general comments?
Yeah, just a couple of comments on cost. We get this question a lot at TuckerAllen. People will ask, even if it's just a family member, they'll ask, but they need to be paid, right? The answer to that generally is no, you don't have to be paid as a trustee. You can be paid as a trustee, though. So any third-party trustee that you would list on your trust documents would be paid because institutions are businesses, and that's what they do. But in Missouri, there's no set fee. It's just reasonable costs. So typically it's from 0.5% to 2% of the trust for institutions. For private people or people who may be family members, a lot of times trustees will just agree with the beneficiaries that, hey, I administered mom and dad's trust. I'm going to take 0.5% off the top before I start administering everything else, and that seems to go fine for most cases. But it is something to think about if you are considering a third-party trustee, is that they will charge you a fee to do that, and whether that is a percentage fee or just a fee off the top is something that you do need to look into and be aware of when you are making that decision.
Yeah, and if you're north of $1 million, you think, in total assets, and that includes all your assets that would be converted into investable money, that's probably going to have you paying at most 1%. Now, if the trustee is able to manage your money in such a way that you have the things I mentioned a while ago, you have the reliability, you have insurance, and you have probably a better than average rate of return, let's say, maybe the 1% really is a great bargain. And that is my personal attitude. I can tell you the way I regard it for my personal trust is I think a fiduciary brings a lot to the table, and I'm willing to pay for that. But I realize if you're less than $1 million in assets, then that fee can go up because there's going to be a minimum amount they're going to have to charge per year to cover their administrative costs and whatnot. And that can be like $5,000 a year. The numbers will vary, but there is a minimum threshold. If you think about it, if you were running an institution like that, you would think, well, look, if I take on a customer, the time that's required to manage this account for this trust is, we're going to certainly be out $5,000. So we can't charge less than $5,000. So if the trust is $50,000, we're going to have to charge you $5,000. So if you do that math and it doesn't appear too punitive to you, and I suspect if you're above $500,000, I think you're probably looking at maybe a little more than 1%, but maybe not. It depends on the market at the time. What are people earning otherwise? So I'm still a fan. My recommendation is if you have a significant amount of assets that it makes sense to pay to have it run correctly. Because remember, it's what good is it to create a trust if it doesn't go down the way you intend for it to go down for the next 100 years, right? I mean, you can easily have a trust for 100 years. So one thing, though, that let me talk about how decisions are made with co-trustees. You can require unanimity, meaning everybody has to agree. So let's assume you have 3 trustees. You could require all 3 to agree. But like an example that you gave a while ago, Ben, with signatures, often that's difficult to pull off. So putting aside signatures for a minute, but talking just about making decisions. What the Missouri Uniform Trust Code requires is that when you have co-trustees, that there be a majority decision. So as long as a majority concur in a particular decision, then you're good. Now, you may say, well, what if somebody strongly disagrees and it turns out to be a bad decision and money is lost? So let's assume that we don't have an institutional trustee for a minute. And it could happen. You remember, institutional trustees are not fail-proof, but I can't. It's when you read the cases and see where things go wrong with multiple trustees in terms of investment, usually there's not a fiduciary involved usually. So let's put that aside and let's say that you've chosen 3 trusted, honest family members, and maybe there was even a successor down the road. So you have this combination of 3 people. And it turns out that 2 of them think that an investment is a good idea. And one of them says, no, I disagree. Well, as long as there's not what the law considers, what the Uniform Trust Code considers a serious breach of trust, quote unquote. So I won't get into the definition of that, but you can imagine serious breach of trust. Absent that, meaning it's just a judgment error, for example, then there are no consequences. Even if it's negligent, there's no consequences to the person who opposed it, but they didn't take action to alert the beneficiaries. So let's say one of the 3 felt this business idea to invest in these SPACs, for example, is a bad idea. And so they vote against it and they let it be known to the others that they oppose it. But they don't go to the beneficiaries to voice their complaint. That person is still protected from the liability that's going to result from that negligent decision because it wasn't what would normally be considered a serious breach of trust. I mean, a dishonest act, an act where there's a conflict of interest or self-dealing. Those are things that are kind of felonies. I mean, when you're a trustee, if you do that sort of thing, those are the major things where you get hit hard, maybe even criminally, but certainly everything that the civil courts can throw at you. But in a case where it was negligent, it was a bad decision, shouldn't have been done, but you can imagine how often do family members do negligent things? I mean, how often did your parents make negligent decisions in terms of investments? How often have you made negligent decisions? So when ordinary people become trustees, sometimes it's still negligence and it's somebody else's money. So it's not as harmless as it's bad enough when you make a negligent decision regarding your own 401k, but it's worse when you make a negligent decision. And negligence means not simply you're wrong. It's more than that. It's meaning that you should have known better. And so in the example that I gave, One hesitancy that some people have in being a co-trustee is that they're going to be on the line for everything that is decided in a majority scenario when they may disagree. Well, the good news is that as long as the person disagreed and it wasn't a serious breach of trust, then they're not going to be held accountable. They're not going to be asked to repay the money, in terms of they're going to be sued and get a judgment against them by the beneficiaries, which all these are good things, incidentally, from your standpoint. From your standpoint, this is a good thing. You want your beneficiaries to have remedies, and the law gives them remedies. That's the good thing about this. But from the standpoint of a trustee, they may think, I'm not paid well enough to do this. I need more than if I'm going to be on the line for these two people I'm serving with, who my personal opinion is I don't think that they're able to do this as well as I can do it, and often trustees think that about each other. So the good news is, though, every trustee is not automatically held responsible for the acts of the trustees collectively, as long as they dissented. Now, what if it's a serious breach of trust and they didn't take action? This was a famous case. I won't go into great detail about this, but it's a very influential case in the state of Missouri. And it involved what was then Boatman's Bank. Do you remember that name, Boatman's Bank? Well, people in this area know Boatman's Bank. So it's Boatman's Bank, and I'm trying to think of the family's name. But it was a lady she was 92 years old when this action was brought. And her husband had created a trust, and it was technically a revocable trust, technically. It was a revocable trust, and the husband had died, so it was a joint trust. So she's still, kind of a co-settlor. And her son and the Boatman's Bank were the co-trustees. So Boatman's Bank and her son. Well, her adult son, starts taking over, kind of managing things like her husband had before his death. So she's kind of going about her life. This relationship starts I believe in the 30s or 40s. I mean, it's been going a long time, decades. And so she's going about her life. Her son turns out to be a bit of a ne'er-do-well, and he gets involved, decides he's going to become a real estate developer. So he gets the money from the trust. Now, remember, he's a co-trustee. So he, as a co-trustee, votes to take the money and invest it in his limited partnerships. And he was going to go into real estate syndication. So it turns out that most of the assets in this trust were used to invest in his projects. Hoyt Campbell, you can look up this case, but Hoyt Campbell, I remember, is the name of the son. So so he invests it in these projects. Boatman's Bank just sits by passively and signs off on this. And this goes on for decades until ultimately the money is gone. So the guy files bankruptcy, the son files bankruptcy. So it turns out this money in the trust that was invested in this son's projects is gone. So this woman, the 92-year-old woman, finds out that she's been rendered maybe not destitute, but a good portion of her money's gone. And Boatman's Bank is saying, look, it's not our responsibility. Your son said that he told us he had talked to you and that you thought it was a great idea. But actually, the son said, no, I did tell her about it, but I didn't tell her any more than that because I didn't figure she would understand it. So here was a trustee that was self-dealing, that's the phrase, and there was a conflict of interest. So, I mean, this is the worst scenario you can have in terms of felonies of being a trustee, so to speak. Felonies, maybe literally felony, but I mean serious breaches of trust. So this woman sues Boatman's Bank. Well, Boatman's Bank is indignant, right? They're saying, well, look, what are we supposed to do? The trustee tells us, our co-trustee tells us that he's informing her, even though Boatman's Bank did not permit any of their trusts to be invested in investment like this. As when their trustees running any of their trusts for clients, they never invested the money. As a matter of fact, they testified that they had sold assets because they thought that similar assets were too risky, which was incriminating to them. So it's really shocking to read this case. But Boatman's Bank at the time was just indignant. They thought, well, what are we to do? You know, we rely on our co-trustee who says that they're talking to her, and she apparently knew about it. So if she knew that these investments were going on, it should be end of discussion. But really, the more you think about it, the more outrageous it is. The expert that was chosen to run the trust by her husband and implicitly by her was the bank and her ne'er-do-well son. And they both were responsible. So one co-trustee, and this is how they settled this law in Missouri, one co-trustee cannot say that I relied on the other co-trustee and I knew implicitly they knew this was bad, what was going on here, but they didn't feel a duty to tell her because the son said that he had talked to her. And so the Court of Appeal, this went up the bank lost on the trial level, went up the Court of Appeals. And I can tell you, Court of Appeals was really harsh in their ruling against the bank. You know, you can't collect money as a trustee and then feel you have no obligation to communicate. Even when you know a serious breach of trust is occurring, you have no duty to say anything to the person who's entrusted you with this very sacred responsibility. So Boatman's bank was out the money. I mean, the son couldn't pay it. He was broke. So I don't know how many millions were involved in this decision. I didn't see the number printed in the decision, but it was shocking. And this was in the 90s that this decision came down. So the story I told you really gives you a lot of insight into how trustees work and what's expected and the implications of co-trustees. So I like stories like that, especially that's the wonderful thing about case law. Don't you think so for lawyers?
Oh, absolutely.
Yeah, case law.
All the stories of every case are fascinating.
Yeah, you need that sort of real life, set of circumstances to understand the law. That's the way when you go to law school, you're taught law using case law, because it really allows you to flesh out and understand how the dynamics work in a way that if I had just read you the rules just now, you still wouldn't get it the way hopefully you kind of get it in that scenario. And there are similar cases around the country where trustees have been really dinged. And often the ones who get hit hardest are the now criminally they're all treated the same. But the ones who get hit hardest financially are institutional trustees because they have the money. So when things go wrong, they're the ones who can get the money. If it's your cousin or Uncle Bill will probably file bankruptcy. Or if he didn't, he's going to as soon as he gets a judgment from your children who will sue him for his mismanagement of the money, he will simply file bankruptcy. Now, if there's fraud involved, that's a different question. It's not dischargeable in bankruptcy. Furthermore, he may find himself in prison. So a little more discussion about trustees than we've given in the past, but I hope this is useful. Do you have anything else to add, Ben, of topics we're going to hit on?
I will add, just talking about trustee duties and keeping each other in check if you have co-trustees. If anybody listening is a trustee themselves, know that we discussed an alternative to choosing a third-party trustee to handle financial matters is that the trustees themselves can delegate authority or hire CPAs and realtors and things of that sort to help them administer the trust if they don't have that financial know-how. Trust can be drafted in that you can bar that from happening, but most trusts allow for trustees to do that. And that is an alternative if maybe somebody's a little leery on, I don't want a third-party trustee right off the bat. You can leave instructions in your trust to allow your trustees to use third parties and reach out so they do not breach those fiduciary duties themselves.
Yeah, excellent point. And would you just spring from there, since imagine you're talking to trustees as well as to prospective settlers, talk about the option of having somebody bonded.
So the bonding is an option for trustees, and what that means is you have a bond company that they'll have to apply to this company, and they get a surety of a certain amount, and all that says is this bond company is guaranteeing that this trustee is trustworthy and they're not going to self-deal or have issues about creditors, etc. Bonding, it's for that exact reason, to ensure that somebody has good credit and they don't have a bunch of debt that they would be at risk of using money to self-deal or pay off that credit or debt there. In probate, which hopefully, if a trust is set up correctly, you avoid probate entirely. But in probate, in order to administer an estate, that estate administrator has to be bonded. So it's something that courts have recognized that this is something important, so that we need a trustworthy, bondable person in charge of the estate. So it is something to think about if you are making a trust yourself. Maybe you do want to make sure that, I know my family member and I know they're really trustworthy, but I'm not sure if they're going to get into debt later in life, and I want to make sure they're bonded. And then that way, that will kind of filter out, if you list several successor trustees or multiple co-trustees, that could filter down and kind of filter out any sort of misgivings or self-dealing that could occur with your estate.
And let me clarify something too, is that lest you think that the trustee, if they have bad debts, that somebody can sue them and take trust property. Now, assuming the trust, and Ben's thinking there's something wrong with the trust that's set up, assuming the trust is set up correctly, and this is a trustee, then you don't have to worry about your assets being taken by his or her debts. His or her debts often become an issue because the trustee is tempted to take money and to use it for their debts. So generally, a bonding company that you go to ensure the management, the proper management, so to speak, against fraud especially, but even severe negligence. The reason you go to them is you want this insurance company. You want to be insured and to know that there's protection. Well, they in turn, these companies, will look at somebody's credit rating. And if you've appointed a trustee who has bankruptcies in the past and other things, I can tell you, they're going to have trouble getting bonded. And that's a good thing because it tells you need to get a different trustee. So bonding is an alternative. It's a way to have an individual and still have recourse to the extent that there's some fraudulent conduct or whatnot by this person. Now, it may not, the bonding, it depends on the policy whether it covers simple negligence, mistake like that, and it may, but it certainly would cover egregious or what's called gross negligence. It would cover fraud. So bonding is huge. I'll tell you, Missouri law has changed recently when it adopted the Uniform Trust Code. Each state can change it, can kind of add dots and tittles or whatnot to different things that they want to change. But in Missouri, the prior law had been for 100+ years in Missouri that there was a presumption that somebody had to be bonded, a trustee had to be bonded, unless it specifically said in the trust they were not to be. Now that's reversed. Unless it's specifically said in the trust that they have to be, in Missouri, a person is not bonded. So if they're an individual. And the court has the authority, though, to still require it. They can require it of their own initiative, even though it wasn't said in the terms of the trust. But it's funny, Missouri law has kind of turned upside down on that. Now you don't have to have it unless it's required. But I'm just telling you that if you're appointing an individual, you may want to have them required to be bonded. And it does mean putting some money up. That money may come out of the trust ultimately, which is not unfair, I guess. It is a cost, you could say, to having the trust. And the person, after all, is stepping up for a position that they didn't apply for, probably. If they did apply for it, you might have some reservations if they're too enthusiastic to do it. But if it's somebody who's qualified and is going to do a good job, then bonding is probably a win-win. It's a win for them if they make a serious mistake that maybe they didn't think was egregious, and it protects you in the event that something goes south and your plans don't all go out the window. I mean, you have a multi-decade plan with this trust, and if you can ensure at reasonable cost, we won't go into what those might be, but at a reasonable cost to have bonding done, then it's something you ought to consider. You'll automatically have it if you're dealing with a fiduciary, with a professional fiduciary, I should say. So anyway, we'll stop at that. We could keep talking about trustees. It's a huge subject, and the more you know about it, quite frankly, the better if you're entrusting your dynasty to the proper drafting and the person who effectuates that vision. This has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.